two. I've seen two. Third might be on his.
In the matter of Akhtar and the provision of state for war information.
Yes, just one thing. Excuse me, Usher. You couldn't just email my clerk and ask her to bring me some water. Thanks. Right. Yes. Ms. Leventhal.
My lady, my lords, I appear with my learned friend Mr. Jack Anderson and Mr. Admas Habsalasi. My learned friend Celia Rooney appears as she did below for Mrs. Akhtar, the respondent. May I just check, because there has been further material submitted to the court, and I
Yes.
check that the court has everything that I have.
Let's
We
see.
should have an original, quite slim core and supplementary bundles, which were part of the original materials.
Yes.
And then a witness statement volume, witness statement of Mrs. Walker.
Witness statement in a broad sense.
Yes, containing a lot of historical materials, yes. And 21 tabs of exhibits.
Yes, we have those.
And then there is original volume of authorities and then a supplemental
Yes,
volume
we
of
have
authorities.
those.
Then you had 2 original skeletons and then
Yes.
2 subsequent skeletons.
Yes.
So that's all.
Can I just say that some of the exhibits are, because they're old documents and they've got a very dark background and dark, they're not
Super legible.
they're not super legible exactly. So if there are bits that are viewed by either party to be of critical importance, it would help to have them in a more legible form.
I appreciate that.
And I think the important bits have been extracted and put into the statement, but it's just that they're, as I say, some of them are not. And thank you for saying super legible.
Indeed. Part of the situation, I think, is that with remote working, it's been quite difficult to ensure
Right.
that everything's
Yeah.
clear. But as you say, I think the key parts are in the witness statement,
Yeah.
and if they're not, we'll make sure we supply.
Thank you.
Thank you.
And perhaps I certainly have both lots of skeletons. I just see that I have in fact only brought with me into court, well, I have not brought with me into court Ms. Rooney's second skeleton. I think we're unlikely to be getting to it. I'm sure, be able to find it in my room at lunchtime. But will you be prepared to hand one up if you need to later? Well, no need to do it now. I think it'll only confuse me because the other one's marked up. But thank you for the offer.
Just by way of timing, there is quite a lot of material to cover. The matter's listed before you for a day and a half, but we're very keen to try and keep to that, of course, as much as possible. I had an opportunity to discuss with my learned friend. I had hoped that I would be finished by the middle part of the afternoon. It may be that I have to just see how we get on.
Yes, we are anxious to do this, well, obviously to do this properly, but there's a lot of detail. We will not be criticising you for taking it too slowly. on the legislative history and really working out exactly what the regulations mean. Some of the policy in Article 14 stuff maybe we can take rather more quickly. But don't worry about that. I hope we'll finish within the estimate. But
Thank you.
don't cut corners unless we invite you to.
Yes, indeed. Well, that's very helpful. Thank you. So,
can I just ask one other thing before we start? I know before Ms. Rooney was appearing pro bono, and I think her solicitors likewise. Is that still the case?
I understand that legal aid has been granted, but
Yes, my
Well,
lord.
we're pleased to hear that.
Legal aid was granted very recently, but has been backdated to the beginning of November.
Good. Thank you very much.
So, my lady, my lords, the court has three basic issues. The first is the construction of the regulations. Whether the 1975 regulations on their ordinary construction include Mrs. Akhtar's relationship with Mr. Akhtar as a polygamous marriage, which is in fact monogamous. It's common ground that that marriage at English law was void and therefore strictly takes effect only as a cohabiting relationship. But that's not...
But only as a...
Cohabiting.
Cohabiting, sorry.
Relationship. So we say the answer to that is that it doesn't come within the regulations. And that has been the way that it's been approached by the commissioners and the Upper Tribunal in a line of cases. And that's the main issue on the construction as between the parties. If the court finds against you on that issue, then Article 14 doesn't arise. But if it does, then it does. If you find for the Secretary of State on the construction issue, then Article 14 arises, and that's the second two issues. The first is, the second of those subsequent issues, is whether the failure to award Mrs. Akhtar bereavement payment is a breach of her rights under Article 14, read with A1P1. And then finally, if so, whether the regulation should be read down to remove that incompatibility. And I should just clarify on this third issue that that remedy point relates both to widowed parents' allowance and to bereavement payment. You may have picked up from the Upper Tribunal's judgment below that the Secretary of State had accepted that in line with the McLaughlin case, Mrs. Akhtar's relationship was to be treated as a long-term cohabiting relationship in line with the McLaughlin decision. Therefore, it is going to be addressed in the subsequent legislative response to the declaration of incompatibility that has already been made. The issue before the Upper Tribunal was whether she could be given a remedy on the regulations under Section 3. So I just wanted to make that clear.
So, but this is only in relation to the payment, effectively, for her as a carer of the child of the
Correct.
Relationship. So that's WPA rather
Correct.
than BP.
Indeed.
Yes.
So the issue that arises on all of the points is bereavement payment, the one that relates simply to her status as a spouse or a married person. So, in terms of just so the court knows where I'm going, by way of structure, I'm going to put my submissions under 8 heads, and hopefully the first set of them will be relatively short. We've tracked the history through and set it out in the witness statement form of Mrs. Walker's witness statement with exhibits. What I propose to do, my 8 parts, is number 1, just very briefly on the facts, because I'm sure the court will have grasped those from having read the materials. Secondly, give you an overview of our position on construction. Thirdly, an overview of the principles we say apply to that issue of construction. Fourthly, and this is the main meat of it, chronological look through the historical materials and the statutory provisions in their context. Fifthly, look at the Commissioner's and Upper Tribunal previous decisions. And then sixthly, summarise my submissions on construction arising out of that material. And then the 7th point will be Article 14. analogous situation and justification, and the 8th final point will be remedy.
Yeah, I think some of those can be taken very shortly, but let's
Indeed.
let's see how we go.
Yes. So on the facts then, just firstly and briefly. At the centre of the appeal is the fact that, as a matter of English law, Mrs. Akhtar was not married to Mr. Akhtar, as a matter of English law. And that is because Mr. Akhtar was domiciled here and remained married as a matter of law to his previous wife, Mrs. Bibi, when he underwent a religious ceremony with Mrs. Akhtar in Pakistan. So that's common ground, that as a matter of English law...
But just one
Of course,
I think on my desk you'll find the second skeleton, the respondent. It's not the end of the world if you can't find it, because I'll get it at lunchtime. But it might also be in my backpack. Sorry about that.
that situation was never, although it could have been, was never regularised. Thus, the religious ceremony that occurred in Pakistan was and is void under Section 11D of the Matrimonial Clauses Act, 1973, because it was a polygamous marriage as a matter of law, i.e. there were two spouses at the relevant time.
Hang on 1 second.
So it was a polygamous marriage as a matter of law and thus void. The question then is whether it can nonetheless have an effect for social security purposes, and if not, whether Article 14 points to a different result. The basic facts are not disputed, and I hope been encapsulated in what I've just said. We've set them out for reference in our first skeleton argument at paragraphs 5 to 13.
When you say it was void under Section 11D, it was void because it was an actually polygamous marriage.
Correct.
If it had only been a potentially polygamous marriage, it would not be void.
Correct.
Under Section 11D.
Indeed. Because at the time when it was entered into, Mr. Akhtar already had an existing wife.
Yes. So 11D is designed to ensure that a marriage is not treated as void when it is only potentially polygamous. And that was the intended purpose and the change in whenever it was, 1975.
Yes, and we'll come to exactly how that manifested itself in the Hussein and Hussein and later amendment to reflect that intention. The original intention, certainly as it was set out in the Law Commission's material, was that it should be void even when only potentially polygamous.
Yes, so 11D only impacts on actually polygamous marriages.
Indeed, correct.
It impacts in the sense of makes them void.
Yes. In terms of the basic facts, we've set them out at paragraphs 5 to 13 of our original skeleton. And I won't read those out or go through them, but they are just simply stated there. And they are not in dispute. Both the Upper Tribunal judge and also my learned friend in her first skeleton refer to the outline that I've just given as a technicality, in that although there was no marriage as a matter of law, it was a technical defect. We say that's not the correct analysis. We say the legal situation is clear. Mr. Akhtar pronounced a religious form of divorce for his first marriage, a talaq, and then returned to Pakistan for a second religious marriage. The law required him, as a British citizen, domiciled here, to comply with the necessary requirements in order to give effect to his divorce. and
Sorry,
second marriage.
you said citizen. I don't think that has anything to do with it. does
Sorry,
it?
I should have simply said domiciled here.
Yes.
Yes. In order to give legal effect to his divorce and second marriage, we say that those requirements are clear and are straightforward. And they've recently been looked at in a case that my Lord Justice Moylan was involved in Akhtar, and the more recent Akhtar, or rather the first Akhtar. Divorce and marriage must be undertaken according to the law of England. And the Secretary of State would submit.
Sorry to keep interrupting you. When you say it must be undertaken according to the law of England, I'm not sure that I fully understand what you're saying. The ceremony, whether it's valid as to form, is determined by the law of the place of celebration. So this was a ceremony of marriage that, as a matter of form, was a valid ceremony of marriage in Pakistan. Yes?
Yes, indeed. Yes. What I was referring to was the divorce aspect of that.
Right.
So
I see. You're referring to the talaq in England was not effective as a divorce.
correct.
Right.
And
Sorry,
so-
I misunderstood.
Yes, sorry, I wasn't clear. And then Mr. Akhtar pronounced the talaq and then returned to Pakistan and married Mrs. Akhtar.
Can I just ask, this is probably an irrelevant question, but just in case, suppose they had both, as a matter of fact, been in Pakistan when he pronounced the talaq. Would that have made a difference? Presumably not, because they've both been domiciled in the UK. It would have made a difference from our point of view. It's not where he physically was when he pronounced the talaq. It's where he was domiciled. I think that's a very obvious. This is a less
It's
familiar area of law to me than it is to my lord and my lady.
Perhaps myself also.
Sorry, can I?
I don't
My
know
lord
the
can
answer to
answer.
That
that
depends on
question.
the provisions of the Family Law Act 1986,
Right.
because it would then be a non-proceedings divorce, and that sets out when a non-proceedings divorce is recognised. And it depends on, well, anyway. So the answer is it might be.
Right.
Yes.
I'm afraid to say I can't.
No, it's my fault for raising a point that doesn't matter, but I'm just thinking around it.
Indeed.
The key point is here it was not valid for English law purposes
It was.
because he was indeed they were both domiciled here.
Indeed.
No, it's because the talaq took place here. That's what made it not valid.
Yes, and the marriage. Yes, so the talaq took place here.
So the validity of an overseas divorce obtained otherwise than by means of proceedings. So it wouldn't be valid because he was domiciled here. Both parties have to be domiciled in the country in which the talaq was effected.
So will
So it's the same. So my lord's right. It wouldn't be effective because, again, he was domiciled
here.
here.
So had the talaq occurred there or here, it wouldn't have been effective. It needed to be regularised, as it were, under English law in accordance with the provisions of what you need to do in order to effect a valid divorce.
Well, yes.
Well, it would have been valid if they'd both been domiciled in Pakistan at the relevant time, even though domicile was resumed here subsequently. That's the point that my lord is making.
Well, there's an additional, neither party were habitually resident. So, I mean, anyway, it's the provisions of the Family Law Act, and there are circumstances, all I wanted to point out is there are circumstances in which a talaq effected overseas will be recognised under the Family Law Act 1986.
Yes.
Was Mrs. Beebe domiciled here?
I don't immediately know the answer to that question. May I just check?
You don't need to. I'm sure somebody could know
We'll
the next day and a
we'll
half.
provide the answer.
Yeah.
Ms. Rooney thinks she knows the answer.
I certainly think for our purposes, we're certainly not going to take a point on it because we would presume that she was. She was here from about 3 months after Mr. Akhtar in 1976, so she's been here for about the same length as he was. So
Was-
I expect she would have been domiciled.
And did she die in the
She
United
did die in the
Kingdom?
UK,
Yes.
although at a time when they were living apart.
Thank you.
Sorry.
No, thank you very much. So, the point I was making was that the reference to the technicality is the suggestion that because a talaq had taken place, but no English divorce in accordance with the provisions of the relevant legislation in England, that was a technicality. We say that wasn't a technicality. The requirements to undertake a divorce in England and Wales are clear on the face of the law. And the Secretary of what did occur was that Mr. Akhtar subsequently went through a divorce after that, but he had already married Mrs. Akhtar in Pakistan at that time. The Secretary of State would submit that one can reasonably expect to have to legally divorce one wife before taking another, and that if one is told to enter into a legal divorce, this is what occurred, that Mr. Akhtar was advised that he should enter into a legal divorce after that, there may also be a reasonable expectation that that second marriage would need regularisation. Now, we don't say that in order to be critical of any individual or any person at all, but we do say that the legal provisions are there for a reason and they are straightforward in that respect. And so the legal effect of what occurred is therefore common ground. And that results in a situation where, as I said in opening, at English law, they have the status of cohabitants. So that's the points I wanted to make on the facts. I'll then move on to a summary, my second point, which is the summary of the construction issue. And it's a simple dispute between the parties. Our basic submission is that the provisions of the 1975 regulations, properly construed, were intended to include polygamous marriage, which is in fact monogamous, but only
Sorry, I
when-
just take this slowly.
Yes. Were intended to include a polygamous marriage,
The provisions of which were
the 1975 regulations.
Yeah. Okay. Intended to include a polygamous marriage.
Which is in fact monogamous, but only in the sense that there is a valid such marriage at English law, not one which is void ab initio, because it is not a marriage at all. And so,
Sorry, that's only in the sense that there is that it is a valid marriage under English law.
correct.
Right.
So if you have a valid marriage,
Yes.
if it is in fact monogamous, at the time that the claim is made for benefit, then you're entitled to rely on it for the purposes of the benefit.
Sorry, hold on. In fact, monogamous, you added words there. At the time,
The claim for benefit is made. It may have been once polygamous,
right,
but the critical question is whether or not at the time you make your claim for bereavement payment, you are the only lawful surviving wife of your spouse, your husband, in that situation.
so you were saying there are marriages that might have been actually polygamous that will have become treated as monogamous for the purposes of the claim for benefit. Is that what you're saying?
That is the logic of the regulations.
Right.
The critical distinction.
So yes,
sorry.
Go on.
The critical distinction that lies between my learned friend and I is that Mrs. Akhtar's marriage, when entered into, was void. It cannot therefore be a marriage, polygamous or otherwise, because it is void.
In English law.
In English law.
The regulations don't refer to English law, do they?
They do not.
So this was a marriage between Mr. and Mrs. Akhtar that was recognised in Pakistan.
Correct.
under law. So that's the issue between you, isn't it? Whether a law, as referred to in the regulations, refers to a law of England and Wales. That's it, isn't it? That's the issue.
That's the issue. Yes. And if the court accepts that in order to qualify under the regulations, it needs to be a valid marriage as opposed to a marriage which is void at English law, then it follows that my construction is correct. If, as my lady puts to me, it's sufficient that it's valid under the law where it was celebrated, then my learned friend's construction is correct.
I understand. You keep saying if it's a valid marriage, but of course the difference is it a valid marriage in the jurisdiction of this court, or is it a valid marriage anywhere else? And that would include the place of celebration, in this case Pakistan. And that's what you keep saying, a valid marriage, but it's more than that. It's a valid marriage. Do the regulations require it on its terms to be a valid marriage only insofar as the law of England and Wales is concerned?
I appreciate that the issue is somewhat circular in that one has to start with what is validity and where...
I'm only taking the point, Ms Leadenhall, because you keep referring to a valid or a void marriage. It's a valid UK marriage or a valid marriage. But when you're addressing us, you're referring to the UK position.
I am.
Yes.
Sorry, I just want to clarify this. I think we're going to put your timing out at this rate. So what you're saying is that they only apply if the marriage is potentially polygamous at the outset and then becomes actually polygamous at some point. Or how can you give an example of a polygamous marriage to which the regulations do apply and a polygamous marriage to which they don't apply?
Yes.
Or you're probably coming to that later, are you?
Yes,
Do you see what I mean? Because
I do.
what you're saying is that you can have I'm trying to work out how on your, or perhaps come to it later, how on your interpretation it applies to different examples.
We'll come to it now,
Yes.
because we can always come back to it a second time, but otherwise we'll just be on tenterhooks.
yes, indeed. What I will hopefully show you via the legislative background is that the time the 1972 and then 75 regulations were introduced, the question of validity and domicile were at the forefront of those considerations. And so the only marriage that would have been intended by virtue of those regulations could have been one that was valid under UK law. And so that's the threshold question.
Right, but my Lord's question was give us an example.
Yes, I will. So the kind of marriage that could qualify for the purposes of bereavement payment under the 1975 regulations would be, for example, the marriage of a person who has domiciled in Pakistan. Assume for the sake of argument that Mr. Akhtar had remained domiciled in Pakistan. He had been married to Mrs. Bibi in Pakistan, and he then subsequently married Mrs. Akhtar in Pakistan. He comes to the UK. Mrs. Bibi dies, and he and Mrs. Akhtar are therefore in the UK. The marriage has been entered into at a time when he was domiciled in Pakistan, and he only has one surviving spouse. So the marriage was, in fact, polygamous once, but now, in fact, monogamous, because although it was once polygamous, he only has one surviving spouse. And he didn't enter into the polygamous marriage at a time when he was domiciled in the UK.
So the crucial point in your example is that the marriage was valid according to what we would recognise as being the governing law.
The law of the place of celebration
Yeah.
and the law of domicile. The law, the personal law, as it's called in the historical material.
So, in short, your example, in short, would apply in a case where the actually polygamous marriage was valid by the law of the place of celebration being the place of domicile of both parties. Have I got that right?
Yes. The examples where it makes a difference can be seen in the Commissioner's decisions and later Upper Tribunal
Well,
decisions.
we having encouraged you to tell us now, that gives us enough to whet our appetite.
Indeed.
And we'll then wait for the rest.
At least it was a direct answer to a direct question, which is a start. What I was going to say, just before I move on to that material, this construction works both ways, because a subsequent marriage or an earlier marriage will also fall to be determined by those same principles. And that is what we will see in the Commissioner's decisions and Upper Tribunal decisions. So it will sometimes be an earlier spouse who is the person who remains validly married to the person who dies. And it will sometimes be a later spouse. And it will sometimes be neither. But that is determined by reference to the validity in UK law of the relevant marriage. So that's the second stage of the submissions, trying to encapsulate what we say is the principle, the construction that we put on the regulations. The third set of submissions is a short one. It's just the principles of construction. There isn't anything between the parties on this apart from as to the principle of settled practice and whether that is a useful tool or permissible tool of construction. To encapsulate the point, I can take my learned friend's skeleton argument, because she's put a reference to the case of Black in the Supreme Court and Lady Hale's speech. We don't have any issues as to the correct principles of construction.
This is the new skeleton,
The new skeleton.
of which I now have.
Paragraph 63. I can give a cross-reference to the case itself. I can obviously go there if the court would like me to. But the basic proposition at 63 is that the court will consider the language, its context and its purpose in construing the statute, the regulations here. And it will also take account of a necessary implication. This is the fourth line of the paragraph. A necessary implication is one which necessarily follows from the express provisions of the statute. And that, as considered in Black, albeit that this is, that's the subsequent line, albeit that this will include consideration of the purpose and the context of the legislation. So a necessary implication is one which follows from the express provisions, including its purpose and its context. And so those principles apply here. As to the principle of settled...
And do you agree with that?
I do.
Yes.
I do agree with that, yes.
It's just that you said that you were going to...
It's
There
rather-
was an issue between you.
Sorry.
This is rather odd. You've quoted Ms. Rooney summarising your case.
Yes, what I was trying to get
He does
at-
it more succinctly than you,
She
though.
does,
Yes,
yes,
actually.
in that paragraph, certainly, if not elsewhere. We had put the case on the basis of ordinary principles of statutory construction. Ms. Rooney's pointed out that what we're really saying is necessary implication, and she's quite right about that. It is necessary implication, and necessary implication includes both the context and the purpose of the legislative materials, and that's what Baroness Hale was getting at in black at paragraph 36. And the cross-reference for the court's note is the supplementary bundle of authorities, tab 29, paragraphs 36 on page 559. So rather than turning it up now, I'll just give you that, because it's not disputed. The only principle of construction between us is as to settled practice, and I'll come to that when I look at the Commissioner's decisions. We say you can take account of it, and Ms. Rooney would say you can't, or that it's obiter only. So that's the principles. We rely, therefore, on 5 aids to construction, and I'll just take them briefly, and then I'll move to my 4th set of submissions on the legislative background. The 5 aids to construction that we rely on are, number 1, the mischief and therefore the purpose of the provisions. Number 2,
Hold on.
sorry,
Right.
the mischief and the purpose.
Yeah.
Number 2, the context, and in particular, that validity by reference to domicile was a clear rule throughout and was intertwined with the provisions that we have before us.
Hang on 1 second.
Sorry, what was the last? I didn't hear throughout and
intertwined with the provisions we have before us.
Third.
The third is the consistent meaning of the words and concepts of marriage and spouse throughout all the legislation. And their particular importance in terms of the benefit in question here, bereavement payment. And that's true of the statutory provisions that deal with the benefit, sections which I'll come to next, sections 36 and 39A of the 1992 Act. It's also true of the enabling power for the regulations, section 165, the 1975 Act, as it was then. And it's also true of the polygamous marriage regulations. They all use the concept of marriage and spouse, and we say that that is important in terms of the construction. Fourthly, there are public policy aspects which underpin that construction that we will see from the Law Commission's report of 1971, of not encouraging or permitting polygamous unions for those domiciled in the UK. And the 5th aid...
Well, marriages, not unions.
Sorry, marriages.
Marriages.
Marriages. And the 5th is settled practice. So those are the aids to construction that we say support that construction of the 1975 regulation. So moving on then to the main background material. This is the legislative background and context, and this is the 4th stage of my submissions. I said I would start with the benefits at issue. Can I ask the court to turn up tab 1 of the authorities bundle, please, the main authorities bundle.
Did you say tab 1?
Yes. Tab 1 of the main authorities bundle. Should, I hope, find section 36 of the Social Security Contributions and Benefits Act. This is, you'll see at the top, it says superseded. What we've done here is put in the relevant provision as it was at the time, but you'll be aware that both bereavement payment and widowed parents allowance have now been repealed with effect from the 6th of April 2017 by the Pensions Act 2014. Anyway, for present purposes, you're concerned
I'm
with
sorry,
this
I'm
provision.
embarrassed to say I hadn't picked that up. I have now. Does that mean, as such, those benefits no longer exist?
As such, they have been replaced with a further benefit called bereavement support payment.
But is the language governing entitlement the same?
It is.
Yes.
Yes. And indeed, it's also been the subject of subsequent judicial decision in line with McLaughlin in a case called Jackson, which we can come back to. Effectively, in a nutshell, what the court held in Jackson was that the same applies to bereavement support payment in relation to the child aspect. Widowed parents' allowance and bereavement payment have now effectively been merged into one, bereavement support payment, and the court in Jackson held that the McLaughlin line of reasoning also applies to the child element, the child-related element of bereavement support payment. So the problem continues, as it were, the legal issue for the Secretary of State continues into the new scheme. That's the current state of play.
Notwithstanding the McLaughlin decision.
Correct. The current situation is that the Secretary of State has announced her intention to take forward a remedial order to remove the incompatibilities from the legislation. That was made on the 20th of July 2020 in answer to a parliamentary question.
Sorry, again, is that in the skeleton somewhere and I've just missed it?
I don't think it is, actually, and I can put it in writing if that would assist.
Well, obviously it's not directly relevant,
No.
but I mean, for someone reading the judgment, one would like to know the whole story.
Yes.
And therefore, I think it would be useful to have a short note saying what's happened about that.
We will do that. I'll put that. I'll check and give you the relevant link as far as that assists. But those are on instructions.
Well, you
That's
have
what's
not one
happened.
but two juniors who can do that between them.
Sure. Thank you, my lord. So, as it applied to Mrs. Akhtar, section 36, you'll see from subsection 1 gives an entitlement to bereavement payment where a person whose spouse or civil partner dies on or after the appointed day. And then there are two conditions. A is being under pensionable age at the time of death, and C, the contribution condition. Neither of those are at issue here. But subsection 2 is also relevant. It shows that bereavement payment relates to a sole spouse, as it were. A bereavement payment shall not be payable to a person if that person and a person whom that person was not married to were living together as a married couple at the time of the spouse or civil partner's death. So in other words, if the surviving person is already living with someone else, then the bereavement payment entitlement does not apply. Now again, that doesn't directly apply here, but it's an indicator of the focus of a sole spouse, a sole partner. That's section 36.
But what is it? Because if you look at it, it's going to apply to those who are still legally married, but living apart for whatever reason. And subsection 2 seems to be relating to that situation. The purpose of the payment is to assist those who have been living together as a married couple or in civil partnership to get through the period of bereavement. But this isn't in any way suggesting that it doesn't apply that it applies to all married couples. You can have marriages that subsist, but the actual cohabitation has ceased. This is about cohabitation, isn't it, subsection 2?
Well, my reading of it is that it's intended to deal with a situation where a person's legal spouse dies, but by the time of the death, there has been effectively a separation.
Yes, there's no cohabitation.
Yes.
That's
Yes.
the point.
It's completely neutral
Yes.
from the point of view of the issues, but what you were suggesting in some way supported your instruction. It seems to be completely neutral, isn't it? You said NB the focus on the sole spouse or sole partner. Well, yes, but so what?
Perhaps so. Simply that if a person is already cohabiting with somebody else and therefore doesn't have the need for the bereavement payment in the same way, then the bereavement payment is not payable.
No, it doesn't say that. They don't even have to be living with somebody else. According to this, a bereavement payment shall not be payable to a person if that person and a person whom that person was not married to or in a civil partnership with were living together as a married couple at the time of the spouse's or civil partner's death. Oh, I see. Yes,
Yes,
sorry.
I think that's
Yes.
simply that,
I
but
can
it's,
see
as I
it.
say,
Yes.
it may not bear very much weight.
Yes, I understand.
Yes, I mean, it simply provides that if you're living with somebody else as a married couple, you aren't entitled to the benefit.
Yes.
Right. So you have, I think,
So,
as clearly as you appropriately can, made it clear that you're not pursuing that point.
It's not, yes, my lord.
Okay, right.
So, just so that the court's aware, it's a contributory benefit, therefore, based on a person's national insurance record, and it's not means tested. And without taking you through the detail of the amounts, it's a one-off payment of £2,000. And as the court's already noted, it's not dependent on having children. So it's different in that respect from widowed parents' allowance. But as my lady pointed out, it's intended to help with expenses arising on a spouse's bereavement. So that's section 36. And if the court would turn over then to section 39A, widowed parents' allowance, you would hopefully have that on a subsequent page. Do you have that?
We have.
The same applies, as I said, to the... It's been overtaken by the legislative scheme. But this is the provision that is related to a child. And you'll see, again...
So sorry, I mean, you say it's been overtaken. I'm sure you're right, but you haven't done it quite the same way. What we've got, it says it's still in force to today, isn't it?
It does. I think we tried to replace that page, but it may be that we didn't.
Well, I've got one saying version 10 of 10, 2 December 2019 to the present.
Yes.
So I should write against that. Well, hang on. That can't be right, can it? Because the other provision
My lord, my understanding is that it's common ground that it wasn't in force after the relevant period for Mrs. Akhtar. Can I undertake to just put that?
yes,
in the
it
note?
doesn't matter. It's just so we get it accurate.
Yes,
Yeah.
have the exact relevant provisions before you. So for present purposes, it's similar conditions in little a is a person has to have died before the day on which Section 30 of the Pensions Act comes into force. So I think that's probably where the point about the Pensions Act comes into play. But let me just ensure that that's completely correct over lunch. The second is that the person has not married or formed a civil partnership after the death before that day. And the third is person is under pensionable age. And then you'll see that under the following provisions, the entitlement is dependent on having a child in respect of whom child benefit is paid.
But no, I'm not getting at you for showing us this carefully, but
No.
surely all that matters ultimately is the phrase spouse or civil partner.
Yes. Indeed. And my lord, it's simply so that the court has at least seen those before I get us deep into the woods of the 1971 report.
just looking at subsection 2 again, satisfied the contribution conditions for a widowed parent's allowance. So there are some contribution
It's similarly
conditions.
contributory in the same way as bereavement payment. So yes, sorry, subsection 2 deals with the contribution, and then subsection 3 explains the child that qualifies. Now, just again, so the court understands the position, this is a weekly benefit payable for parents with dependent children of £121.95 a week. So it's that provision that in respect of which in Northern Ireland there's been declaration of incompatibility.
And how long does that subsist for?
The declaration of incompatibility.
No. The weekly benefit. Because it doesn't continue throughout the child's life.
No,
does
it doesn't. I've written down what the situation is for bereavement support payment, but not what it is for widowed parents allowance. So can I undertake to come back to you on that?
Yes, that may explain why, in this case, we have got the version where there was a one-off entitlement to the bereavement payment, which arose.
One-off entitlement to bereavement payment.
Yes, whereas this was a continuing. So to be absolutely strict, we ought to have the version that was in force when it was first claimed or when the entitlement first arose, and then any subsequent versions for as long as the entitlement continues.
Continued, or would have continued, indeed. So those are the benefit provisions, and then in order to get to the regulations, we need to go through the history of the first sets of provisions and how they develop, because it will be relevant in my submission to the intention of those and the construction of them. So what I'm going to start with, please, is tracing the statutory provisions governing the treatment of polygamous marriages for social security purposes to show that this was intertwined with the matrimonial law of validity. And what I'd like to do is take up the exhibits to Mrs. Walker's statement, which include some of the original Commissioner's decisions. And the starting place, if the court would please take that up, is tab 14. This is the beginning of the road, if I may put it like
And
that.
as part of this, you're going to take us through the matrimonial landscape.
Yes, I'm going to do that by reference to the Law Commission's report because it summarises a lot of the material we need. What I'd like to do is start with this decision, then I'll go to the Law Commission's report. But the backdrop to this decision is that at the time of this decision in 1952, so it's a decision of the Tribunal of Commissioners, of the Commissioner, Social Security Commissioners, in 1952, at a point before there was legislation treating polygamous marriages in any particular way for social security purposes. So this was the precursor to what became Section 3 of the 1956 Act. And you'll see from the head note or the summary that this was a marriage that took place in Sierra Leone according to what's called their native law, which allowed polygamy. It wasn't actually polygamous, it was only potentially polygamous. But the tribunal held that widows' benefit, as it was then, was only payable where the marriage was undertaken in the sense of the law of Great Britain, i.e. the voluntary union for life of one man and one woman to the exclusion of all others. So that's effectively what's become called the rule in Hyde and Hyde. And you see the summary of the facts from paragraph 3, but for present purposes it is simply that, what I just explained, that the couple were from that country, they married in Sierra Leone, that in principle permitted polygamy, so it was potentially polygamous. And then we see, if you look over the page, over paragraph 3, that the Commissioner held that the claimant's marriage was valid because the custom of the Crew people permitted polygamy.
Invalid.
GA was entitled to take one or more wives in addition. And then looking over to, cutting through the rest of it and taking you over to paragraph 19, 20 and 21 on page 393, HW 393. You'll see at paragraph 19 reference to what I just termed the rule in Hyde and Hyde. So at that time, a marriage undertaken under a law which permitted polygamy was not treated as valid at all, including for social security purposes. And the Commissioner, in paragraph 20 and 21, if I can just ask the court to just briefly read those paragraphs. particularly paragraph 21 and 22. So, although it had never been polygamous, it wasn't capable of being relied on at that time for widow's benefit. And in particular at paragraph 21, a sort of situation that was being referred to there was tracking the history at the time of people from countries such as Sierra Leone coming to the UK, having married there, but not being entitled to rely on the validity of that marriage for the purposes of social security purposes. But that was the position under the law as it then was. So that's the starting place. And then what I'd like to do is pick up the history as it was from that in the witness statement, body of the witness statement of Helen Walker. And it's the relevant part for present purposes starts at paragraphs 35 to 36. So on page 15, my lady and my lords have the witness statement at the front of that bundle. On page 15, you'll see paragraph 35, which refers to that case that I've just taken you to and summarises it. So I don't need to ask you to look at that, just to see that that's where I started. And then over the page, she has summarised that decision. And then picking it up at 37.
It's clear though, isn't it, that we've got to be careful to have regard, as you say, to the actual wording of the paragraphs 20 and 21, 22, because some of the summaries of Miss Walker are very, very helpful, but may miss points that we're interested in.
Absolutely, and we therefore need to ensure that we look at the legal provisions where they directly
Yes.
apply, of course.
Yes.
And so what Mrs. Walker then does is explains at paragraph 37 that subsequent to that, the National Insurance Advisory Committee made recommendations responding to the 1952 situation, that case. And what followed that, over the page, was the first provision, that was section 3 of the Family Allowances and National Insurance Act 1956. She has set out the provision in full there in paragraph 38. If the court would like, just for cross-reference purposes, the provision itself is at Supplementary Authorities tab 2, page 4. So what happened, the first...
So sorry, just before we get there.
Yes.
It is still the position that the report of the committee itself has not been able to be obtained.
We've kept on trying, but we haven't been able to find it. I'm sorry.
No, we're very grateful for all the work done. Having said that, it is a bit surprising that in a country like this, which has good national records, an important committee, but there we are. If it isn't, it isn't.
Yes, and what we have got is perhaps not the next best thing, but a good thing, which is a minute which summarises the conclusions, which I will come to in due course. But what has been taken there in Mrs. Walker's statement has been taken from that. So it is effectively section 3 is what we need to look at, because that encapsulates what was introduced and the background reasons for that. The best we have as a
yes.
Is
well,
there.
thank you. That's obviously helpful. But don't give up. I think for completeness with an important case like this, it would be nice to see the report of the committee itself.
I'll set the chain running to find out how far we had eventually got. I think we'd tried again at Kew, the National Records Office, to try and get hold of it again. I'm not sure how far that had got. Again,
Okay,
but
well, let's not spend more time on it now. But I
I
think we'd like to have it if we
Indeed.
can.
Sorry, can I just stop for a moment? The benefits legislation is national. The law of marriage is not national. England, Wales, Scotland, Northern Ireland.
Yes.
So your submissions have to fit with the interpretation of marriage in Scotland and Northern Ireland insofar as it's different from England and Wales.
Yes.
Sorry to raise, it's because these are all, the benefits legislation is national.
Is the benefits legislation common to Northern Ireland as well? I know it's common to Great Britain.
Well, my understanding is that social security is a devolved issue, but that, and I'll be corrected if I'm wrong, that ordinarily, for example, in Northern Ireland, there's very similar provisions are usually enacted.
Yes, it's
So
devolved to Northern Ireland, not to Scotland.
May I just confirm with those behind me?
Yes, I see. So the note I'm making is social security legislation common to Great Britain, Northern Ireland expected to be similar but technically correct, technically different. And then the second half of my Lord's question, obviously the marriage law is different in each of the three countries of the United Kingdom. We've seen, however, that in Re G, the commissioners made a point of saying that the law of Scotland was the same as regards Hyde and Hyde. There was a reference to a Scottish authority which presumably says the same thing. I've forgotten now what it was. But,
Yes, it was in tab 14. It's Fraser's treatise on husband and wife according to the law of the law. In tab 19 of that judgment, tab 14, page 393.
Yes, no, that's what brought it to mind. That we need to perhaps have an understanding of what because it will have changed as well over time,
Yes.
won't it?
I have to admit that we haven't done the exercise in relation to Scotland.
No, I'm not.
But so for present purposes, for Mrs. Akhtar's case, of course, it doesn't apply. But of course, I understand that the court will want to have an eye to that also. If there's anything that we can do in relation to Scotland that we need to do, we'll happily do it.
Because this, I think you're saying, is this fits under or intertwined with matrimonial law. So that if there are differences, then that might impact on
it might well
the
do.
interpretation.
I'm not aware, so far as my researches have gone, I'm not aware of anything specific in relation to Scotland that's different. But that's not.
I'm not getting at you, but if you haven't looked at Scotland, you wouldn't know.
No, well, quite. That's all I meant.
Yes.
Ignorance is.
Well, I mean, the obvious question is there an equivalent to Section 11D in Scottish matrimonial law?
I don't know the answer to that question, my lord. I can't pretend to know it, and I wouldn't want to.
No,
imply
I mean, that is the question.
Yeah.
Yes. Well, speaking for myself, I'm afraid this too is something which, with the resources of the government legal department and two juniors, it'd be tricky but not impossible to
We will definitely
to
do
get
our
an
best.
answer quickly. It won't be
Yes.
difficult at all to get an answer in time,
I'm
but
sure
we'd
we
like
will.
to get an answer
course.
sooner rather than later.
Yes. So, where I was section 3, at paragraph, which is set out at paragraph 38 of Mrs. Walker's written statement. And that relates to a marriage performed outside the UK under a law which...
I'm so sorry, which paragraph did you say?
It's paragraph 38.
Yes, I have it.
Yes.
Yes, thank you.
And I'm just reading the section. Marriage performed outside the UK under a law which permits polygamy shall be treated for any purpose of the Family Allowances Act, and so on, as being and having at all times been a valid marriage, if and so long as the authority by whom any question or claim arising in connection with that purpose falls to be determined, is satisfied that the marriage has, in fact, at all times been monogamous. So this was the original provision which related to marriages which were at all times monogamous. Now we know that later on it becomes in fact monogamous, and we'll see how that progress occurred. But this was the first provision.
But it's also significant, isn't it, Ms Leventhal? Because if you look at it, not just in the final words, but as from the appointed day, a marriage performed outside the United Kingdom under a law which permits polygamy, it doesn't talk about personal capacity there. So this provision actually recognised polygamous marriages of those in situations such as we have immediately before us. The issue then was whether or not it had all times been actually, in fact, monogamous. So there's another important difference, isn't there?
I understand entirely the question your ladyship's putting to me. Certainly the wording says under a law which permits polygamy.
Yes.
And we take that to mean the law of celebration, as in the law in
Yes.
the place in which it was celebrated.
Yes.
It doesn't say anything about the law of domicile and personal law.
That's the very issue I'm putting to you.
Yes.
It's saying a law which permits polygamy. And in this case, we do know, don't we, that in Pakistan, the marriage was regarded as valid regardless of the domicile of Mr. Akhtar.
For the purposes of Pakistani
Yes.
law. Yes. Yes.
Yes.
And
I'm only taking you to
No,
that
I
on the
completely-
basis that you've taken us only to the last 7 or 8 words.
Yes.
Has in fact at all times been monogamous, showing that there's going to be a change in the regulations that we're going to come
Yes.
to. But I'm merely pointing out that it's a bigger issue that's being tackled in this paragraph than just at all times monogamous.
yes, I accept that on the face of the legislation it doesn't say anything about domicile and validity. I entirely accept that.
All right, that's all I needed to point out.
And I'm grateful, and I apologise, I should have gone to that line, your ladyship's quite right. What we do say is that what we could see in the 1952 decision was the sort of situation that was being considered, namely the context historically then related to people coming into the UK who had married in their country of origin, and that was largely the context for the issue, because the rule in Hyde and Hyde, which is also the backdrop to this, which was referred to expressly therein, meant that a marriage would be void if you were domiciled here. And so you do have that collision of those two questions. Now I appreciate that there's nothing specific there that says what I would want it to say, or what I would say it would say on the basis of what the 1975 regulations say. But I don't accept that means it doesn't apply by way of necessary implication insofar as it needs to.
Well, that's why you need to go through, need to take us through, doesn't it, the history of
Correct.
the common law and then statutory approach to the issue of capacity.
Yes. So just to finish off that point, and then we will go into the 1971 report. What you see in paragraph 39, and in order to try and not spend time on things which don't affect the argument, section 3 was then replaced by section 113, the 1965 Act. You see that in 39, and section 86(5) of the National Insurance Industrial Injuries Act 1965, and section 17(9) of the Family Allowances Act. Now we certainly have the first two of those in the supplementary authorities bundles.
Sorry, I keep going back. I think your submission is that from the outset, as a matter of statutory necessary implication, this was predicated on neither party to the marriage being domiciled at the date of the marriage in the UK. Is that right?
that was certainly the issue that was being addressed.
That's your submission.
Yes. Insofar as that then flows into the 1975 Act, well, the 1971 Act, then the 1975 Act, and the 1975 regulations.
And from what, I mean, how do we get that necessary implication just looking at Section 3?
We get it by understanding the collision of hide and hide and the mischief that the Act was intending to address, namely a situation where a person who was a couple who were only ever monogamously married, coming into the UK, settling here, and making a claim for the relevant widowed benefit. That was the issue that was being tackled. Now, the 1971 report, which we'll come to, is very clear that nothing that it recommended or considered was in place at that time was intended to encourage a person domiciled here or to validate a person domiciled here entering into a polygamous union outside of the UK. And so that hide and hide preservation, which we will see in the 1971 report, I say assists with that argument. But I put it on the basis of the mischief and the hide and hide principle that was at the
Just hang on one second. No, just sorry. I mean, obviously the word domicile doesn't appear. That's why we're talking about necessary implication. But I'm just trying to see what the concept, a marriage performed outside the UK, so that's just the celebration, under a law which permits polygamy, must mean, mustn't it, that by the domestic law of conflicts, that was the operative law. And by the domestic law of conflicts, that would depend on domicile, wouldn't it?
Yes.
I'm thinking aloud rather than...
Well, yes.
I'm just wondering what we get out of the concept of a marriage being performed under a particular law.
Well, I think it may be helpful because it may be helpful to go to the 1971 report because it does explain
Yes, okay.
that. And I appreciate that we don't get a huge amount from just that paragraph, from just that section. But it is clearer when one sees what types of conflicts the Law Commission was considering in 68 and then 71. So for present purposes, the court just needs to be aware that that section 3 turned into 65 Act and so on provisions in paragraph 39, but nothing turns on any change in wording so far as I'm concerned.
Hang on, sorry, just give me a moment.
So then one...
Yes, sorry, you go on.
Thank you, my lord. So what I propose we then do is turn up the Law Commission report of 1971, which is in the same bundle at tab 11. And just so that the court is also aware, at tab 10, we have the 1968 working paper, which was effectively the consultation version that was then setting out the various proposals and policies that were consulted upon, and the 1971 report is in tab 11. I don't propose to go through the 68 report because the salient points are in the 1971 report in similar form. So I propose to take them from the 71 report. Simply otherwise, because we may never get to the end of this. What I would ask the court to start with then is simply paragraph 1, the introduction, which explains the scope of the exercise. So pausing there, we had our section 3, and then what the Law Commission was doing in paragraph 1. It explains, do you have that? It's page 121, HW 121, first page of the main page of the report. Explains that they had a working paper number 21, that's the document I just referred you to in tab 10, the elicited comments. Study has been limited to the question of recognition of polygamous marriages for the purpose of family law and social security legislation. So it was looking at both together. And they then use the terminology at paragraph 2 of potentially and actually that we've also been using and understanding in that way. But both were at that time referred to as polygamous marriages, i.e. entered into a law, entered into under a law which permits polygamy. Whereas maybe only potentially polygamous or actually polygamous, depending on whether the person has actually had a second spouse. Now, I just want to pause there. We've effectively 3 themes that go on through the report. The first is validity and domicile. And I'll take these in turn, but I just want to make the 3 aspects clear from the outset. Validity and domicile, in respect of which no change is recommended. That's point 1.
Hold on 1 second. Yeah.
Secondly, recognition for matrimonial relief purposes, change is recommended. That's number 2. So recognition for matrimonial relief, change is recommended. And thirdly, social security, change is recommended. So just if we have those points clear as we go through. Continuing then through the report, paragraph 4, the court explains that reform is clearly needed and talks about the situation at issue there. Echoing the situation that the commissioners were concerned with in 1952, 5th line up from the bottom, there are, however, a number of cases where, because the marriage was celebrated abroad in Islamic or customary law form, it is potentially polygamous, though the husband has in fact only one wife. There are also cases of actual polygamy where the husband has one wife in England and one or more wives in his country of origin. So that was the useful summary of the sort of situation that the Law Commission was looking at there. What we then have in section 2, I'm not going to go through the whole report paragraph by paragraph, but there are a number of places which I do need to take the court to, so do please bear with me. Paragraph 5 deals with the rule in Hyde and Hyde, to which we've already referred. But importantly, the basic principle of English law concerning polygamous marriages is that neither party to such a marriage is entitled to matrimonial relief. And that's the aspect, one of the aspects of which the Law Commission was recommending change. May I just allow the court to read, if it hasn't already, that paragraph which summarised the situation in Hyde and Hyde. In a nutshell, yeah.
Yes.
Yes. So we then have paragraph 6, the wording that we saw cited by the Commission in the 52 decision. Marriage as understood in Christendom may be defined as the voluntary union for life of one man and one woman. And so that's effectively the rule in Hyde and Hyde as it was then understood. If we turn on to paragraph 9, you'll see the 2 basic principles principles as the Law Commission summarised them. Neither party, so this is 9A, neither party to a polygamous marriage is entitled to any matrimonial relief, whether the marriage is potentially or actually polygamous. B, however, a polygamous marriage which is valid by the law of the place of celebration and by each party's personal law is generally recognised as valid in England, except for purposes of matrimonial relief, which has just been dealt with in paragraph 8. So when I was referring to place of celebration and personal law, that's what the Law Commission was understanding as the circumstances in which potentially polygamous or actually polygamous marriages can be valid, if they are valid by reference to the place of celebration and by each party's personal law.
Does personal law mean effectively law of domicile?
That's what it means. And there's a cross-reference to paragraph 111, which explains that, and we'll come to that in due course. There's a footnote there that refers to it.
When it says generally recognised,
yes,
does that include generally recognised for the purposes of social security legislation?
they come on to deal with that specifically
Okay,
in
fine.
the later part. Yes,
Right.
but they're giving an overview there.
And let's not spend time on this, but we do notice that, at any rate, this part of the report, they are taking the trouble to note that the law of Scotland is the same,
Yes.
as both in footnote 19 and in footnote 21.
Yes, thank you.
Yep.
And then 10A is also important. The application of these basic principles has resulted in the development of substantive law. The main rules are: A, the nature and incidence of the marriage according to the law of the place of celebration, and not the law of either party's domicile, determine whether a marriage is monogamous or polygamous, and so on.
Hang on one second, sorry.
Shall I just let the court read that paragraph, if I may?
Just that subparagraph 10A.
Yes, subparagraph 10A.
Okay, thank you. Yes.
And then the next critical passage is on validity at paragraph 15 on page 127, or internal page 7.
Yes, I certainly don't want to slow you down. We must do our own
Yes.
reading, but I mean, B and C are quite interesting as well.
They are.
I should think the whole of paragraph 10 is, isn't it?
Yes.
Lavender.
Yeah. Okay, well.
There's also then an explanation in the latter paragraphs of Ali and Ali, and the question of acquiring a domicile and so on. For present purposes, I'd like to just focus back on the validity issue,
Yes.
because I don't think a lot turns on it for my specific points.
Yes.
But if the court is going to read it, if it hasn't already, that whole passage is worth reading, please. Paragraph 15 deals with then the validity, which is what I say is the important backdrop to the way that these provisions need to be understood. For purposes other than matrimonial relief, may be of importance to establish whether a polygamous marriage is valid or invalid. Conflict of laws, formal validity of the marriage is governed by the law of the place of celebration and the essential validity, including the capacity of the parties by the law of their domicile. And then we have 16 under little a is polygamous marriages celebrated in England. Have that situation, but it's important to note the first sentence of 16, Dicey and Morris on conflict of law, that a marriage celebrated in England in accordance with polygamous forms and without any civil ceremony is invalid, whatever the domicile of the parties. And then paragraphs 18 and 19 are of particular importance to our situation. because, in short, there is no capacity to enter into a polygamous marriage if you're domiciled in the UK. So can I just ask the board please to read 18 and 19? So what we have was the first of my aspects, no change in validity. So the Law Commission was not proposing to make any change to the test of validity of polygamous marriages. So that was its starting point and the backdrop to what follows. The case for reform on matrimonial relief is then addressed in paragraphs 20 onwards, and if I can just...
Yes, it may be just, well, here, footnote 47, I think maybe the footnote you were referring to earlier, or may not, but where they explain why they talked about personal law rather than domestic,
Yes.
which in fact I think is opposite, is presumably dicey. I'll let you check. Yes, it is. Yeah, okay.
Correct, thank you, Michael. So they then summarise the rule in Hyde and Hyde, paragraph 20, and at paragraph 24, the Law Commission looks at what they are concerned with, by way of context, the type of situation, albeit in the case of matrimonial relief, but the type of situation that they are concerned with in paragraph 24. This is the third line, second sentence. The real problem concerns the positions of persons who have married abroad in polygamous form and who now reside in England. They may be immigrants or they may be persons of English origin who have married according to the locally recognised form.
When the phrase says in polygamous form,
Under a law which permits polygamy.
yes, that's all it can mean,
Yes.
isn't it? Yeah.
So potentially or actually polygamous, in other words.
Yeah, thank you.
We then have a summary of the relevant propositions at paragraph 24. And then I think that we can pass over, for present purposes, to paragraph 41, which is effectively the upshot of the Law Commission's recommendation on its second aspect, which is matrimonial relief, where they recommend change. So having recommended no change on validity, we then have paragraph 41, recommend change on matrimonial relief. They say there's no longer any justification for denying all forms of matrimonial relief to polygamously married persons resident in this country. But while we favour the general principle and so on, we therefore propose to examine in detail the various different types of situation. And again, I think for present purposes, I don't need to take the court through each situation, but can then move to the conclusions at paragraph 61 on page 141. There was obviously a majority decision that it was appropriate to take this course.
Sir Neil Lawson dissenting, is that right?
Indeed, and I think that we have...
Well, don't worry, no, I was just...
have a memorandum of dissent on internal page 46 towards the back of the report from one of the members of the Commission, I think, who did not agree. But for present purposes, that probably doesn't matter too much. What is important for my purposes and for the court's purposes, is to understand that it was at that time controversial, understandably, and that in paragraph 61 the Law Commission was making very clear what it was and wasn't suggesting and what its, as it were, policy drivers were for its recommendations. In support of this view, we would emphasise our recommendation to extend matrimonial relief to parties to a polygamous marriage would not result in the legalisation or recognition of something which has hitherto been forbidden or totally unrecognised. Polygamous marriages are already recognised for most purposes except matrimonial relief. Now that's that reference back to what we saw, recognised where valid under the personal law and under the law of the country. And we'll come to what that means in answer to my
yes. What purposes would there be other than matrimonial relief and no doubt social security, but ignore that for the moment. What sort of things did they have in mind?
They're talking about situations like as a succession.
Yes, I see.
And things like that.
Thank you. Yeah, that's a sufficient answer.
And importantly is the sentence, nor would our recommendation permit anyone to enter into a polygamous marriage in this country. The only marriages in respect of which relief would be granted are those validly entered into abroad. No marriage entered into in England can take effect as a polygamous marriage, nor would our recommendation enable or encourage any person domiciled in England to enter into a polygamous marriage abroad. Such a marriage would be void. And so on. And the final sentence is again important. Our recommendation would mean that where parties have lawfully entered into a polygamous marriage abroad, they settle in England, the English court would recognise and enforce their matrimonial rights and obligations. So it was a limited recommendation to deal with that particular purpose, but against the backdrop of the validity issue, number one, no change, and against the backdrop of a careful understanding that it was not to be taken as encouraging or enabling a domiciled person, an English domicile, to validly enter into a marriage abroad of polygamous nature, by which it means potentially or actually polygamous.
And we see the mischief at which it's aimed at in paragraph 62. The husbands who are attempting to avoid their obligations to a wife.
Yes. And then, as my lady points out, actually over the page as well, that's carried through into the final conclusion at paragraph 63. Should be carried to its logical and just conclusion. The parties to such marriages should be encouraged to conform to English standards of behaviour. And I think it means in terms of legal, by having so far as it's practically the same rights and obligations in marriage as other married people living in England. So that was the recommendation then. And then in sections 14 and 15, so section 14, sorry, I should just pick up one paragraph as on our way there, which deals with nullity, because that arises in due course in relation to 11D, section 11D. On page HW149, internal page 29, we see the recommendations in respect of nullity and reference at para 88 to the law, the court only being concerned with marriages celebrated abroad. This is the second and third sentence of 88. In paragraph 89, this again the statement of the principles we've been looking at. Marriage is also regarded as void if either party lacks capacity to the law of the domicile of that party. A person who is domiciled in England has no capacity to enter into a valid polygamous marriage. The effect of marrying in a polygamous form would render the marriage void. And that's a cross-reference back to what we looked at in paragraph 18 in the footnote. Our proposals do not alter these rules, except to allow the parties to marriages which are void on any of these grounds to petition the English court for a decree of nullity. So that was the the limited intent of the Law Commission at least. Now, moving on then to the question the court was asking me, what are these other situations in which it might be valid and or needing to be relied on? If you turn over to section 14 on page HW156.
I'm ever so sorry, before you get there, this paragraph to which you've just referred as paragraph 89, the Law Commission were recommending that even if there was a void marriage, that it should be possible for one of the parties to petition the court in order to seek a decree of nullity, which is a substantial move forward, because before the courts would just say you're not married and therefore you've got no locus in these courts. So if there was a situation where here, and I'm not talking about this particular marriage that's into abuse, I make that clear, but there had been another situation, similar situation, where the wife had petitioned for nullity. Does that give it any greater status than it hitherto had? Does it elevate it from a void to avoidable marriage? Because that might be important for social security purposes, mightn't it?
My understanding is that that's in part addressed then by the subsequent provisions of the 1971 and 72 Act, which we will come on to. Certainly, the policy reasons we just looked at would remain good for social security purposes.
Yes. But I'm just wondering about the change in status from void to voidable, which seems to be another
In principle, if it was voidable rather than void, it would be
fly in the ointment, as it were.
slightly different.
Yes. Okay.
But I think what also my lady's pointing out is if you look at paragraph 85 as well as 89, what they're proposing is that both parties to a void marriage and parties to what hitherto would have been treated really as no marriage at all, in other words, a polygamous marriage, both of them should be entitled to bring a claim for a financial remedy.
Yes.
So they're addressing it in that. They're saying in 85, if our recommendation concerning divorce is implemented, there would be no longer any of these marriages, which brought with it the entitlement to make
The matrimonial relief.
to matrimonial relief.
Yes. It then does follow in the provisions that subsequently become Section 1 of the Matrimonial Proceedings for Polygamous Marriages Act 1972, which enabled that to occur, and then Section 4, which we'll come on to.
Yes, because we first had the Nullity of Marriage Act, didn't we?
And this amended it, or the subsequent provisions. Well, my lord will know better than I do. But,
No, very imprecise memory.
Well, this
Section
couldn't
4.
have amended it, could it? Because this was the report of 1971 and the Act was 1971.
No, but I think subsequently what happened was Section 4 of the 1972 Act amended the Nullity Act.
I see, yes. So it
flowed
wasn't the
through.
Act that followed on from the report.
Correct.
It was the amendment to the Act that was coexisting.
Correct,
Yes.
I think what they're pointing out, isn't it, is that they are ensuring that spouses will be able to make a claim. So there's no need to address the actually void marriages, because a spouse in those circumstances will be also entitled to. So they don't need to address it in any other way.
That's how they're addressing it in that limited way and no other.
They're addressing it in that way.
Yes, yes. So, moving on then to Section 14. This was we've seen earlier on, there was a cross-reference to paragraph 111, where they were talking, at paragraph 19, I believe. Sorry, it was at paragraph 9b. where they talked about polygamous marriages which can be valid by the law of celebration and each party's personal law. We then have a summary of the situations to which Hyde and Hyde already does not apply, and a citation there from Dicey and Morris. A marriage which is polygamous and not invalid will be recognised in England as a valid marriage unless there's some strong reason to the contrary. And they go on to explain at the end of that paragraph. Cases which will arise in the courts will have to...
Sorry, wait a minute. Which paragraph?
Sorry, I'm in
behind
paragraph 111 on
Thank
page
you.
HW 156. Where they're talking now about the cases in which a valid polygamous marriage can nonetheless be looked at despite Hyde and Hyde. We proceed over the page on 157, top of the page. We proceed to consider some situations in which polygamous marriages, valid by the law of the place of celebration and by the personal law of the parties, have been or may be considered by the courts. And then, in answer to the question my Lord Justice Underhill was asking me about what kinds of situations they might be, we then have an explanation of those different situations
Yes,
there.
thank you.
None of which are directly relevant for our situation. What we have is the social security section, which comes subsequently. But the fact that when they're talking about a valid polygamous marriage, they mean those two bundles of rights, the personal law of the parties and the place of celebration. They say that's important in terms of the understanding of our provisions. So, over the page, if your court could turn to page 41, internal numbering, H61, we then have the position as regards social security legislation. And happily, this should, I hope, now make sense, or at least it did when I was preparing this, because we've seen the situation that gave rise to this. As you see, paragraph 125, we thought it necessary to deal with social security in this report because this field has been the first of decisions, subject to first of decisions, and later of legislation affecting polygamous marriage. So we know we're talking about the 52 decision and then the section 3 provisions that we've looked at. The commissioners, the reference there to the commissioners is to the 52 case, which is footnoted, and indeed other cases that followed on from that, footnote 19. And an explanation given that the citation there from the rule of Hyde and Hyde. And then over the page, at paragraph 126, the Commission explains what I hope I explained to the court, which was that the injustice there gave rise to section 3. And we have there set out section 3. Paragraph 127, the Commission considered, the Law Commission, that this was significant because it was the only occasion on which Parliament of the UK had so far legislated at that time, and that it had had an improvement in the law as previously administered. Just pausing there, we recall that it's section 3 deals with at all times monogamous. But we question, they say, in the middle of para 127, whether the sections go far enough. They do not cover cases where the marriage was once actually polygamous but is no longer. For example, because the first wife died or was divorced before the parties came to England. Nor do they cover cases where the marriage is in fact polygamous at the time when the social security benefits are sought, although only one wife is in the country. There are two different situations, and we will deal with both separately. So they deal then first with the situation in paragraph 128 of marriages which were once actually polygamous, but in which there is now only one wife. And they explain reference there to the case of Imam Din. Shall I ask the court just to read that paragraph, please?
We need to read paragraph 129 as well, don't we?
Yes. Yes, please.
Yes.
So there are two parts to that paragraph. The first is the Iman Din situation, and the second then is these three examples that the Commission posits. May I just deal with the first part of that first? It's important to notice the sort of situation with which the Commission was concerned there was that case where the situation was a couple who had come to the UK after their marriage, and my learned friend refers and relies on the reference in the middle of that paragraph to about 10 lines down in the sentence, we regard this as both unfortunate and anomalous because the second wife, having been admitted into this country as the wife of a permitted immigrant, should be treated just like any English wife. If she was in fact her husband's only wife throughout the period of their residence in England while the husband was paying contributions in England. My learned friend says, well, that's the situation here, in that throughout the period of their residence in England, Mrs. Akhtar was her husband's only wife, at least by the time of the claim. But actually, if you read that paragraph against the context that we are aware of from the remainder of it, the focus is actually on the bottom of that paragraph. It cannot surely be right to compel the husband to suffer deductions and so on. To the woman who, throughout the period of those compulsory deductions, was his one and only wife, merely because at some earlier time before coming to England he had another wife. So it's that sort of situation that the Commission was concerned with there, and we focus on that as being the correct understanding of that. Then as
but is that not because it's looking at it from the perspective of contributions?
It is.
So that's why residence is highlighted, because obviously you only start paying contributions once you're resident.
It is primarily a contributions issue, but in terms of the sort of case that they were considering, it's a kind of situation consistent with what we've looked at earlier of people who have got married before becoming domiciled here, and who are then seeking to apply the relevant benefit scheme to them pursuant to their contributions. Not the kind of domiciled situation we have with us. I appreciate it doesn't say that expressly, but it is relevant context.
Well, the three examples they give under the workman's compensation, the three men involved in the same industrial accident, doesn't go near the situation we've got here.
That's it.
It deals, but it doesn't. It doesn't address it at all. That's the point.
It doesn't. It doesn't address it at all, and you're absolutely right. And there's a reason for that in my submission. It's because at this point in time, and indeed in line with their recommendations, it was never in contemplation that a person domiciled in the UK would be returning to their country of origin to enter into a polygamous marriage, because such a marriage would be void. It would be of no effect. And the Commission has been very clear that it wasn't intending, in para 61 that we looked at, to do anything to change that position. So it's not surprising, I say, that none of those three situations are trying to address the situation of a person domiciled here pursuant to the laws of this country, entering into a marriage which is actually polygamous. So we say it is possible to read into that absence an understanding of the sorts of situations which were contemplated by the Commission and then subsequently by Parliament in enacting the 75 Act and 75 regulations. So what I was going to come on to say was those three cases are not the case we have here, and I've addressed that.
Does the report deal with the situation that we've got here or something similar anywhere?
Not that I can see.
So it never entered their contemplation that we could have a situation where a domiciled husband returns to Pakistan to marry a first or second time. He enters into a marriage that is actually polygamous, becomes subsequently actually monogamous. That is not covered by this report.
It's not covered by this report in the Social Security section.
No.
And the section which does touch on it is paragraph 61 in context.
Which we've already looked at.
Yes.
Yes. But not so far as Social Security is concerned.
No.
So although it was in contemplation in one aspect of the Law Commission's report, as you say, the matrimonial relief, they don't go anywhere near it. They don't even say, well, we don't need to bother with it.
They don't. They don't. What they do say is we're not changing domicile and validity. And this is the consequences, repeatedly, this is the consequences of a person who does enter into a marriage when domiciled here. It's of no legal effect, except for this small creation of exception that we are recommending.
For the matrimonial.
Correct. So that is we have to put ourselves in terms of understanding what the words were then meant. Those were the recommendations. Now, I appreciate that's an absence rather than an express, but...
I was only asking to see if there was anything that I should be looking at.
Not that I found.
It's not in there.
Yeah, but you say the absence shows us the assumptions they were making, which were reasonable assumptions.
Bearing in mind
how they analysed it historically, yeah.
Yes, and bearing in mind the fundamental principle of conflict of laws and validity. So I was going to draw those threads together. Before I do, I think I probably already have, but paragraph 130, we were just on at page 163, HW 163. You recall that they set themselves two types of situation in para 127. The first is a person whose wife died or was divorced before the parties came to England. Then we have those three examples in para 128. They then deal with at 130 with the second, which is where somebody still has two wives, but only one is in the country. And they effectively find that they were not able to discover a solution which we would sure would be both administratively workable and acceptable to public opinion. And that's the last sentence of that paragraph. And so they rather push the point back to the Department for Social Services issue. What they do is recommend, and that just paragraph 131 explains what they recommend, the beginnings of it. They recommend that the Secretary of State should change the law, and they go for what they call a regulating out provision. And that's picked up again at 133 for the sort of the ultimate decision. We recommend that section 113 of the National Insurance Act 1965 and the other provisions, which were the section 3, which is where section 3 had got to. Those provisions should be replaced in each case by a provision that any person claiming a benefit in reliance upon a marriage under a law which permits polygamy should qualify. So they say everything should be in, and the Secretary of State should then be able to make regulations taking them out. And just to finish that point, that was not what happened. That was not what was accepted. It was the regulating in that was chosen, and we'll see that in due course. So that was the recommendation.
I speaking for myself, I just struggle always with the expression under a law it's polygamy, because what we can see a number of references. There's not. It's the law of the place of celebration which determines whether the marriage is potentially polygamous.
Yes.
So that's what they're referring to.
That's what those words.
So they can't be referring to the consequence of one of the parties being in the UK or England and Wales. Because that expression is used under a law which permits polygamy several times. And they're clearly aware that if one of the parties is domiciled in England and Wales, then their personal law or a capacity does not entitle them to enter into a polygamous marriage. So what are they? What is this? I mean, it's referred to in 131, which addresses specifically clause 1263A, providing for regulations to be made specifying the circumstances in which a marriage celebrated under a law which permits polygamy would be treated as a marriage celebrated under a law which does not.
Well, you can see the draft clause at Appendix B, page 54 of the internal numbering. I mean, it's what your Lordship has just said, but it might be helpful to see it there.
What page you say?
Page internal 54.
Yes, I see, yeah.
Yeah.
174.
You see, I think it was mentioned in one case that I can't remember which case it was. It Hussein? Was it one of the other cases that if that's what Parliament had intended, it would have been very easy to have said so. So, in other words, if it had said save where one of the parties is domiciled in England and Wales, which would, as a result, render the marriage void, it doesn't say that.
No.
It's simply focusing on the place where the marriage where the marriage occurred.
Yes, that's what the words say. And my submission, albeit this isn't the exact provision that's carried through, but for the purposes of understanding what was intended by this provision, it's one of those issues which arises or must arise by necessary implication, because of the clear. We're back to necessary implication. When you use the word marriage, you mean a marriage which is understood as being a marriage which can have any legal effect in under the law of England and Wales, UK law.
But this draft doesn't support you on that, does it? Because it is talking quite clearly of a law which permits polygamy, and then goes on to say whether or not either party to the marriage has for the time being any spouse or spouses additional to the party. So my Lord's point, as to, forgive me for saying so, the plain meaning of the words, and I know this wasn't the one that was taken forward, Appendix B, but it is obviously referring to the law of the place of celebration of the marriage, rather than the the personal capacity of the parties to the marriage. And obviously, it may well be so Pakistan recognises a polygamous marriage regardless of the personal capacity of, in this case, Mr. Akhtar. That's right, isn't it?
So in that sense, it's recognised as valid.
In Pakistan, not in the UK. I see that that's the difference. But the Law Commission wanted to break away from that.
Well, I can see that that is one reading, and that's the reading that my learned friend would urge. My submission is that it can be the reading or intention of the Commission, given all what we have just seen. Because if that were the intention, it is completely absent. They did not say they want to break away from the law of validity. They specifically said they recommend no change. I appreciate that that's a piece of the jigsaw, but it's an important piece of the jigsaw. And so my submission is, this is a case where if you had said to the Law Commission, do you mean it has to be valid under English law to even start? The answer would have been yes. Hence, it's a necessary implication issue.
Well,
and that is,
yeah.
I appreciate that that there is a argument to the contrary, which my learned friend will put, but not only is it, in my submission, surprising, as your ladyship put to me, that there's nothing in there to say that that's what they were intending if it was indeed that, but from the moment it started to be interpreted by the commissioners in the Upper Tribunal.
Well, we're going to get to that.
We're going to get to that.
But before we get there,
yes.
Even accepting your context, and I can see that your point is you've got to look at this in context.
Yes.
What we do have is a report that recommends that for the purpose of matrimonial relief, a polygamous marriage that would otherwise be regarded as void in the law of England and Wales should be given a status to permit an application for nullity and therefore relief, matrimonial relief following on. So the context is far more nuanced than you're suggesting, isn't it? Because it can recognise the necessity to stress the validity and the public interest in discouraging people from entering into polygamous marriages, but note that there are consequences that would otherwise be unfair, and they give an example of the 3 workmen. So it's far more nuanced than that, isn't it?
It's certainly, there is nuance in relation to matrimonial relief and other aspects of it.
But if they wanted to make a difference, where's the explicit difference?
The explicit difference that comes is not if you are domiciled here and then you return to Pakistan and enter into a second marriage and come back here, then either you will be entitled to benefit for both or the only surviving wife. It would have to be a marriage which is entered into at a point at which that is a valid thing to do under this law, because you are bound nonetheless by the personal law of this country. And so the change, sorry my lady, the change is essentially the improvement that's being encouraged and recommended is a change from at all times monogamous to in fact monogamous.
But how does Appendix B help you on that? That this draft regulation, that in fact the draft clause, which has been rejected, but if your reading of the Commission's report is right, how does this support that interpretation when it's referring to additional spouses in paragraph 1?
Well, what the Commission's suggesting, recommending, is that you should have a regulating out option to take out marriages which are, for example, and this is what ultimately happens, in fact, only allow those which are in fact monogamous. So even though you may have had a previous wife, more than one spouse, you only, in fact, then have one, because they were concerned with a situation they couldn't find an answer to. Yes.
Yes, I see that, but the point still, I think, is valid.
Yes.
It is referring to the fact that a marriage shall not be disregarded, even if it was actually polygamous. And that doesn't seem to fit into the context that you're suggesting.
Well, I can see that the recommendation and the specific clause doesn't create the narrow answer that the Secretary of State then makes in the regulations and Parliament approves. But the context of the report and the situations that they were trying to cater for still remains good. So they certainly were not suggesting, for example, that you should be able to have benefit in respect of two wives, or at least that they couldn't see a way around it. So they were saying, let's regulate everybody in and let the department take them out.
I see.
But the reasons for the in and out still remain good, if I can put it like that.
Can I draw your attention,
Yes.
to a sentence in paragraph 129? And it's the second to last sentence. And it's dealt with the case of Ali. And then it says, in claims for insurance benefit, the detailed investigation of all the facts necessary to establish domicile should be avoided if possible. Probably quite a sensible suggestion, because domicile can be very hard to establish, particularly if the individual concerned is deceased. So what there is being suggested is that can we remove the requirement to establish domicile and simply look at the form of the marriage if it was conducted overseas? That might be one interpretation. Because otherwise what you're saying is that in every case you need to determine, as at the date of the ceremony of marriage, where were the individuals domiciled? 20 years later, 30 years later. It is quite a complex.
It is, and indeed that is what the Upper Tribunal, Commissioners of Upper Tribunal do. They decide which of these marriages, even if they're both subsisting, are valid, because at which point was somebody domiciled there and here and vice versa and so on.
But you're stressing context.
I am.
And the context is, of this report, can we try and avoid investigation into domicile?
That's one of the points they make in the context of Ali and Ali 129. I'm not sure that we can read it quite as broadly as that, albeit this isn't a statute and so on and so forth, and it's a recommendation, conclusions of a paper. Because the Ali and Ali situation was talking about subsequent domicile, wasn't it? Acquiring a domicile in the UK, and whether that would enable you to rely on the existence of your marriage, even though it had originally been entered into in a polygamous form under a law permitting polygamy. So that was the particular issue that they were saying would be removed, that investigation of domicile. But nothing to say that the whole issue of domicile then necessarily goes out the window, is no longer relevant to establishing which, if any, of your marriages is valid.
But you can have, they may all be valid on the basis that domicile of choice needs no particular objective visibility, but will depend upon the evidence.
Yes.
And in this case, everyone is assuming that Mr. Akhtar's domicile remained the same throughout. Now, it's conceded, I think, for the purpose of this particular case, but there are going to be cases where somebody says, well, I actually had a domicile of choice of Pakistan at the time I contracted this marriage. I then lost that domicile of choice and acquired another one 6 months later, etc., etc. It's very. That's the point to ditch domicile, isn't it?
It's certainly a slippery issue. I can agree with that.
All right.
I entirely understand the points, and I think I've made my submissions about how we say it works.
And just finally on Appendix B, a marriage, a ceremony of marriage, it is a marriage. So what you're saying is that one has to, by necessary implication, include the words a marriage otherwise valid under English law.
Yes.
Those would not have been difficult words to include.
No, they wouldn't have been difficult words to include. I appreciate that. But equally, having read what we've seen, would they be difficult words to imply? And my answer to that is no. Are they a necessary implication? To which I say yes. But
Still, yes. I mean, it's the necessary.
yes. I suspect if I answer the question again, I will just be repeating myself.
No, I'm sure I'll ask it again at some point.
Yes.
Sorry.
The necessary implication perhaps is easier to see. Well, I've made my submissions on where.
Why don't we carry on?
Yes.
And you will have an opportunity to return to the fray with what will have emerged from the other things we're going to be looking at.
Indeed.
I don't want to stop you getting distracted by me.
No, not at all. So, the upshot of this report is then can be seen in relation to matrimonial relief. And I think it's important just to see those provisions as they then were, and before we then move on to social security and tackle the specific ones applying here. So can I just ask the court please to turn up supplementary bundle tab 9. Supplementary authorities bundle tab 9, forgive me. Does everybody have that supplementary?
Yep.
Yeah. So what we see then is two consequences. We have Section 1 of the 1972 Act dealing with the matrimonial relief issue as recommended by the Law Commission. The court in England and Wales should not be precluded from granting matrimonial relief or making a declaration concerning the validity of marriage by reason only that the marriage in question was entered into under a law which permits polygamy. So there we see the nullity decree of divorce issues that under subsection 2. So that was as it were, the main change recommended, other than the social security provisions, which we'll come on to. And under section 4 of this, and then I should say that section 2 and 3 deal with Scotland and Northern Ireland respectively. So the section 2 was in, I think, identical form. Just checking. In substance, it's the same, subject to the different provisions of relief that can be granted under subsection 2, but the emphasis is the same. And the same for section 3, Northern Ireland. But for present purposes, we then have section 4, which amends the Nullity of Marriage Act 1971, to which my lady and I were referring a moment ago. Section 4 is what then becomes section 11D of the 1973 Act. So section 4 here amends section 1 of this Act, the Nullity of Marriage Act, and then in due course becomes section 11D. So that was the main consequence of the 1971 report of the Law Commission, other than the social security provisions, to which I will now come. If you're...
Are you taking us to the nullity of... Sorry, where were you going?
I was going to now go to the, I wasn't going to go to the nullity provisions now, I was going to come to 11D
Right.
afterwards, if
Okay.
I may.
Thank you.
Yes. So if the court would turn back to tab 8,
In which?
in the supplementary bundles, the one that you're in,
Yeah.
turn back a tab, you'll see the National Insurance Act 1971. Section 12 of that act, which is on the next page, over the page, is what was ultimately done in relation to social security. So not the regulating out provision, but a different provision, which then becomes our enabling provision. So if you look at section 12, you will see polygamous marriages. Now, I will take you to Helen Walker's witness statement, which tracks through why and why that was done. Section regulations make provision for any purpose of the Insurance Act and so on, as to the circumstances in which a marriage celebrated under a law which permits polygamy is to be treated as having the same consequences as a marriage celebrated under a law which does not, and so on. So that's section 12. Which becomes the enabling provision for our regulations. I'm just trying to find so I can complete the picture. Tab which deals with section. I'll come to that in due course. Forgive me. So, section 12. That's what is the upshot of the Law Commission's report in relation to social security. And if the court could then go back to Mrs. Walker and her witness statement, she explains effectively why the Law Commission's recommendation was not accepted and what was done and why, insofar as she's been able to elicit it from the materials. So, the Mrs. Walker's witness statement bundle, and I'd ask the court to pick it up at paragraph 48, which is on internal. Page 20. Paragraph, just tracing this back, paragraph 48 sets out that provision that I just showed the court, section 12 of the National Insurance Act. That was the original provision.
Sorry, I've
So it says 48, paragraph 48 says section 12.
yes, I've got it. Yes, I've got it. Thank you. Yep.
It's slightly backwards in the sense of what.
Yes, I know. Just for a bit of working out,
Yes.
but I've got there. Yep.
So the first provision was that. It then went in identical form into the 65 Act, and then for present purposes becomes section 162, which is up the page at 47. For present purposes.
Sorry,
Sorry, I'm
it
doing
couldn't
it
matter less. No. You start with the 71 Act.
You do.
Then you have got, what, 2 enactments in 75?
Yes.
So the section 12.2 of the 65 Act, as amended, takes its language from the 71 Act.
Yes. And also, it finds its way into the 65 Act by an amendment.
Yes, I see.
For present purposes, we...
Oh, well, don't worry, I can work it out. Yeah.
Thank you. So what Mrs. Walker does is she explains at paragraph 50 onwards, as noted above, the Law Commission had recommended that a clause be added to the relevant legislation, such that any person claiming in reliance of a marriage celebrated under laws which permit polygamy should qualify for benefits unless those specific regulations state otherwise. So that's the recommendation that we just saw from the Law Commission.
Can I suggest that we cross out laws and put a law, which is actually what the
Yes.
section and the regulations say, because
Yes.
it does concentrate the mind a little, doesn't it?
It does. And she refers to the enabling power which the Law Commission recommended. And then at paragraph 51, she sets out a quotation from the policy note. What we can do is turn up that policy note, so long as it's not one of the documents which we can't read, I hope. But this is a contemporaneous material that addresses the history and the recommendation. So it's in tab
16.
yeah, well, it's actually in tab 2. It's page 16. Forgive me.
Oh, sorry.
Yes.
Oh, well, there you are. It just shows how.
Well, yes,
trying to
it
be
was
clever.
in pages because I think perhaps at the time we were not tabbed yet.
Yes, I see.
So is this the new bundle or the old bundle of authorities?
Sorry, it's in Helen Walker's written statement.
Oh, in the exhibits, sorry.
Yes, forgive me, my lady.
No, it's
It's,
my fault.
in the So, if you turn to page 16 of that, you will find Appendix 2. And Appendix 2 tracks through the history.
Those,
Tab Appendix 2, it's on page HW15 of tab 2. So it's tab 2.
yes, actually, thank you.
Yes. Now, I'm not going to ask the court to look at all of this now because it's material we've already seen, but this is the contemporaneous material tracking through the history and the National Insurance Advisory Committee, which is the document I referred to, which is at the moment the best we have because we don't have that report.
Yeah.
And then over the page, you see at paragraph 3, reference to the Law Commission's working paper, recommending that section 113 of the 1965 Act should be amended so as to require no more than that the marriage should be in fact monogamous at the time, or in respect of which the benefits are payable. And subpara 2, that an attempt should be made to formulate proposals to make social security benefits available, even if the marriage was in fact polygamous at the time when the benefits were payable. They considered numerous proposals for coping with their second recommendation, but were unable to discover a solution which would both be administratively workable and acceptable to public opinion, which echoes the exact paragraph used. The Law Commission further elaborated their proposals by saying that national insurance legislation should recognise polygamous marriages and should prescribe by regulation the additional conditions to be fulfilled before a person relying on polygamous.
So this is a reference to the working paper, not to the report. Or does it slip into the being?
It is. It's the working paper.
Yes.
Yes.
Which
And
we
the
haven't
report-
seen because you quite
No.
sensibly took us straight to the
Yes,
report.
and
Yep.
you're quite right, my lord. The reference to the report is over the page, but I think for present purposes we continue through. We'll see.
Yes, of course. No,
Yes.
I just wanted to be clear.
Yes, you're quite right, my lord. So, the Law Commission further elaborated their proposals by saying that national insurance legislation should recognise polygamous marriages and should prescribe by regulation the additional conditions. So that's the recommendation that you should have regulating out, as it were.
I'm sorry, I've lost you.
Oh, sorry, I'm in paragraph 3 on page HWC.
Oh, we're still on 3. Sorry, I
Yes.
thought we'd moved
Sorry.
on to 6, but no, it's 3. Sorry, my fault.
This would overcome the objection that a polygamous marriage was by implication not a valid marriage. Paragraph 4, the Department opposed the Law Commission's proposed change in legislation on the grounds that regulations would appear to
So
be...
what we're talking about here is, in modern language, the department's response to the consultation.
Yes.
Yep.
They said the regulations would appear to be a harsh cutting down of general legal rights rather than a benevolent extension of normal legal principles. And it was explained that the department preferred to replace section 113 with an amendment providing for regulations to prescribe the circumstances in which a marriage under the law which permitted polygamy was to be recognised as a marriage for the purposes of the Acts. It was felt that a flexible power of this nature would best enable us to maintain a fair balance between the parties to such marriages and the general body of contributors. Consequently, what happened was it was provided in section 1263 of the aborted NSSI bill, that provision, that fell during the parliamentary process. And then you have reference to paragraph 6 and a summary of the report we've just seen. It may be better if I just let the court read that paragraph rather than me reading it out, because I'm conscious of the time. It may be useful if we could just finish these couple of paragraphs before we pause for lunch.
Do you want us to read 7 as well?
Yes, please. That's just the reference.
He's really only just telling us what we've already seen. I mean,
Indeed.
Yeah.
And then the department preferred its own approach.
Yeah.
And accordingly provided section 12, which is what we've just seen. So that's where we end up. And I think that's on the...
Well, we got a minute or two, but if it's a natural place to break. Right. Well, don't worry about the time you're taking. We'll think about that over lunch. Been very clear and helpful. Right. 2 o'clock.